here. I'm really excited about this week's guest on the Note My Objection show. We've obviously been talking a lot about immigration. And it's really important to me that I bring to you people who actually know what they're talking about, because as we all know, we live in a very divisive climate. We are hearing partisan perspectives, and it's difficult to know what is real and what's not. So luckily, I was joined today by attorney Sarah Cade, formerly Judge Sarah Cade. She served on the immigration court bench from 2021 until 2025. We talked about all different things, from her 18 years of experience with the Department of Homeland Security and ICE and a variety of positions as an attorney and prosecutor. We talked about what it's like when you come to the border, what the process is, what it realistically looks like, the backlog in immigration courts, the lack of reform, and really focused a lot of our conversation on what is happening today in enforcement and within the courts, in addition to the sort of political climate that we're in, and then comparing it with all the administrations that she was previously under. So altogether, I think it was an excellent conversation. We talked for quite a bit of time, and I will tell you, I could have asked, hours more worth of questions, but I was grateful to have her really teach us about what is happening in the immigration court system. So I hope that you will enjoy this. If you like it, please like, share, and subscribe. And that's it. Welcome to Note My Objection. Thank you for coming.
Oh, thank you for having me.
Sarah Cade, you have been in the system for quite some time, and I'm really grateful to have you here because we don't have a lot of voices who actually know what's going on with sort of the immigration issues as a whole. We're hearing so much different information from oftentimes very, partisan actors. And I think most people are really just trying to get a hold of what's going on, what's okay, what's not. And so because of that, I'm really grateful to have you on here to answer some of our questions. We have been talking about immigration quite a bit on Note My Objection. And I think there's a lot to go into. So I appreciate you being here. And I figured maybe we could do a little bit of kind of background of your time in the system, and then really kind of go through on a very fundamental level, what the immigration system is, how it works, and kind of dumb it down for all of us to really understand these sort of complex issues. Because what I have learned, and sort of diving in, is that despite the fact that I'm an attorney and have been in the criminal system for a long time, it's very different than immigration.
It is very different. Yeah, it's a totally different world.
And so can you give us a little bit of a background about how you started in the immigration courts and what your roles have been there throughout your career?
Sure. So first, I think the important thing to know is that immigration courts are under the auspices of the Department of Justice. It's not an independent judiciary. They're administrative courts. I got involved right after law school. I was selected for the Attorney General Honors Program, and I was the judicial law clerk for the courts in Buffalo and Batavia. And the judicial law clerk, for those who don't know, is someone who sort of helps the judges do legal research, do legal writing, writes opinions for them.
Right.
So that was under the Bush administration that I started. From there, after my 2-year stint, I went on to the Board of Immigration Appeals. That's still within the agency, but that's the part immediately above the immigration courts. They review all the immigration court decisions in the country. So anytime someone gets a removal order and they appeal, the first place that appeal goes is to the Board of Immigration Appeals. Okay. And I was a staff attorney there for 8 years. And the staff attorney's job is to take the case, look at the briefing, look at the evidence, and sort of write an initial draft opinion to then go to the board members. From there, I went to ICE in 2018, and so that was under the first Trump administration. And I was with ICE in Boston for 3 years as a prosecuting attorney under the Office of the Principal Legal Advisor. Those are the attorneys that actually litigate the cases on behalf of the government in immigration courts. And then in November 2021, I had the honor to be selected as an immigration judge, and I served as an immigration judge until May of 2025.
And that is, I think, for many of us in the legal community, one of the highest honors you can receive is getting on the bench. And so I congratulate you on that, because you had a long, and it sounds like a career in various sort of parts of the system, which
is, I think, what we want for people on the bench, to have sort of a different experience in a variety of departments within the system. So if we can go back a little bit, you said at the very beginning that immigration judges are not, they're administrative judges, essentially. So it's different than what people think of as a judge in probably the criminal or the civil system, where depending on what state you're in, you are either appointed by the governor or you're elected. In the federal court system, you're appointed and then confirmed by the Senate. And generally, sort of the purpose of that is to ensure independence from outside, political persuasion, pressure from any administration. So can you tell us the difference between that kind of judge and what an immigration judge, sort of who you're accountable to, what it's like, and how it actually functions?
Sure. So immigration judges are civil servants, and they're employees of the Department of Justice. The selections go through the normal civil service selection process where you apply, there are interviews and things like that. Political affiliation is not supposed to be a consideration. And each appointee is then confirmed by the Attorney General.
Okay.
So it's supposed to be a nonpartisan process.
Sure.
And so once you're appointed to the bench, you go through a brief training period of a few weeks, and then you're assigned a mentor judge who can kind of help you as you proceed throughout your career. But pretty quickly, you hit the ground running and are hearing your own cases with your own dockets. The dockets are usually assigned to you. You don't really get much of a say in either the types or quantities of cases that you're given. And you're assigned to a court. On a day-to-day basis, I felt that I had a fair amount of discretion in terms of how I handled my docket, in terms of moving cases and things like that. But of course, every administration has different priorities, and that's going to shift throughout your career. And the immediate supervisor of an immigration judge is an assistant chief immigration judge.
Okay.
They also have their own dockets as well, in addition to managing the court. And then headquarters is Falls Church, Virginia, where you have a chief immigration judge that's underneath the director of EOIR, which is the Executive Office of Immigration Review. They answer to the Attorney General. So that's sort of the line of progression.
Okay. And so is there, depending on, what administration you're in, and I know you said, it's not supposed to be persuaded or controlled by sort of your politics, your partisan, whether it's, you're Republican, Democrat. I think, unfortunately, in the system that we live in, not just immigration, in all sort of facets of judicial nominations and things like that, that it does, unfortunately, play a role. That the idea of impartiality has been, I think in some ways sort of diminished, at least the trust in it, because of what the arguments are around whether people are partisan and if they're making decisions based on whether they were appointed by a Democratic judge, Republican judge. Do you find that, so you were under the Biden administration when you were appointed?
Yes.
And then continued under the Trump administration now, and practiced under George Bush, Obama, and the first Trump administration. Do you find that the guidelines or sort of the directives from the top, the Department of Justice, the Attorney General, all the way down, do they change significantly between administrations, or are they supposed to, and they do or they don't?
So historically, I would say they didn't change all that much. Different administrations obviously have different priorities, and every administration has been faced with the fact that we have a ballooning immigration issue. The dockets on the courts are huge. When I left the bench, I think I had 12 or 13,000 cases. So, which is unimaginable. I could do that for a lifetime and not finish.
Right.
So every administration has had different procedures and ways to try to address that. Under the Obama administration, they instituted this prioritization system where every case had to be classified by DHS attorneys by what priority category they fell into, or if they were non-priority.
Okay.
The Trump administration, the first time around, focused on just trying to adjudicate everything, enforcement as much as possible, and just trying to get the cases out.
Move along.
The Biden administration instituted new regulations to try and streamline things, including some things that removed asylum eligibility from a huge number of people. So different administrations have changed the priorities as time goes on. I think what we're seeing now, though, is a little bit different. It is always the Attorney General has the ability in immigration law to kind of step in and make a decision and interpret how the statutes are being implemented by the agency.
Okay.
That's always been the prerogative of the Attorney General for the immigration courts. And the Attorney General will issue decisions that can supersede the Board of Immigration Appeals.
Interesting.
What I see now, though, is a little bit different in terms of the scale of what we're seeing, which I think is why people are a little bit surprised by the new Trump administration, and I think, too, by the speed of the changes. Typically, changes in law, they can occur quickly, but it's usually a gradual process because in law you want to have some measure of predictability. You want people to know how to proceed through the system.
Right.
And I think what's happening now is things are changing so rapidly and so unexpectedly that it's very, very difficult, even for people in DHS, to keep up with what's going on.
Right. And so, not only from somebody who comes here and is attempting to get citizenship, but also
attorneys,
I assume, the lawyers, and,
Right.
and that has to be difficult because, like you said, with a backload of cases that just number, and so across the country, we must be in the millions. And is there any, if you have 12 or 13,000 cases as an individual judge? All of us know that it's impossible to be able to adjudicate those on all. Were there expectations about how often and how many cases you were supposed to be adjudicating a week, a day, a year?
Yes. So first, let me kind of backtrack a little and sort of explain a little bit on the day-to-day of what the immigration court looks like. So typically when a case comes in, it's first assigned to something called a master calendar hearing. These are cases where we're in the preliminary stages, and an individual master calendar docket will occur either on a morning or an afternoon, and there will be usually between 20 to 40 or even 50 cases on that docket. They're usually very quick. This is when people are read their rights, when we're meeting with attorneys to discuss preliminary matters, take pleadings, figure out, is this person seeking relief from removal, or are they just doing a voluntary departure, or there's no relief available. They're usually really quick. At that stage, generally speaking, most people are going to request relief, usually asylum, not always. At that point, once we've established they are removable and they are seeking relief and we have an application in, then it's set to a merits hearing, also known as an individual hearing. And those are the trials, essentially, for the immigration court. At the immigration court hearings for a trial, you'll have the immigration judge, an interpreter if the person doesn't speak English, it's provided by the court. You'll have the DHS attorney, and then the respondent, who is the person, sort of the defendant in immigration court.
And can I interrupt? In immigration court, these respondents are not entitled to counsel. So
They're
unless they
not.
have counsel on their own, they're essentially representing themselves?
Correct.
Okay.
Most people do ultimately get counsel, either through a nonprofit, a pro bono attorney, or they get assistance from family paying for one. So I would say 97% of the time, in my experience, someone ultimately does get an attorney.
Okay.
So in terms of who's in the room during the trial, that's it. So there's no jury, there's no bailiff. These are very usually small hearings. And an asylum hearing will typically take between 2 to 3 hours.
Okay.
So that's when they give all of their testimony, all of the evidence is put in, examined, and the judge renders a decision, usually an oral decision that day.
And can I ask, so when you say this is sort of the initial step, does that mean when, if I can even go back a little bit more so I can sort of grasp about how this actually looks in practice, does that mean that when someone arrives at a border anywhere, that then they have this they're taken into custody and there's this immediate hearing, or what happens? So if I walk up to the border tomorrow and I say I want to come into the United States, what do they do?
So in theory, what's supposed to happen, if someone presents themselves at a border or is apprehended after crossing the border illegally, then the Customs and Border Patrol officer takes an initial look to see, is this person eligible to come into the United States? Do they have a valid visa? Do they have, are they a Canadian citizen who doesn't need a visa to enter or something like that? If that person can't demonstrate that they're eligible to come into the United States, then the individual is supposed to be asked, do you fear persecution or torture, or some equivalent question?
And I would assume everybody says yes.
Not everybody.
Interesting.
Not everybody, but a lot of people do.
Yeah.
If that happens, they're entitled to what's called a credible fear interview, which means they're allowed to be interviewed by an asylum officer who will ask them questions about what happened to them, why they came to the United States. If that person is found to have a credible fear of persecution or torture, then they're put into removal proceedings.
Okay.
If they're found not to have a credible fear of persecution or torture, then that can be reviewed by an immigration judge. But then that's it. If the immigration judge says, no, I agree with the asylum officer, you don't have a credible fear, they're removed.
Okay. And does that happen when someone arrives at the border and they say, I do have a credible fear, does that happen immediately that somebody assesses the asylum court?
Typically,
officer
it takes a
assesses
couple of days.
Okay.
Maybe a couple of weeks.
them? And where in the interim does that person get taken into custody?
Yeah, usually they're detained.
Okay.
Now, under the Biden administration, when people were discussing how the border was open, usually what was going on then is we were having so many people crossing that the Customs and Border Patrol officers felt they didn't have time to, or the administration felt that people didn't have time to do that whole process. So folks were allowed to enter into the United States after just sort of the preliminary question stating, yes, they had fear of persecution or torture, and then those assessments were either conducted later or they were just put straight into removal proceedings, bypassing the credible fear process.
Okay. And so do you find that, so when somebody comes across the border, if they say that they have a credible fear, they're assessed by an asylum court officer, what about the other individuals? So if somebody says, is there another way outside of saying that you have a fear from, going back to your country? If you answer, no, I don't have a fear, do they just put you back in the system and put you on a plane? How is that what actually happens?
Yeah, basically. If you cross the border either without permission or you present yourself at a border crossing and you don't have permission to come to the United States through a visa, you can't demonstrate your eligibility to enter, and you don't have a fear of persecution or torture, then yeah, you can be summarily removed.
And so for the people who do get the sort of interview or assessment with the asylum court officer, and then they have, then is that where they go into this sort of kind of trial, as you were describing initially? So if they've sort of passed the first test, then
Exactly.
they go
into
you,
removal proceedings.
and you make the decision after the presentment of the case. Now, how long does that generally take between point A, when they're assessed after crossing the border, and they get in front of a judge and have sort of a hearing on the merits?
If the person is not detained, years. I would say when I left the bench, if someone had entered the United States that day, let's say April of 2025, their initial master calendar hearing, where I was reading them their rights and explaining how the proceedings were going to operate, probably was not going to be scheduled until 2028 or 2029. Their final merits hearing probably wouldn't take place until sometime well into the 2030s.
And that's simply because of the backlog.
It's
of
simply
cases.
because of the backlog.
So after the initial assessment, and an asylum court officer says, okay, we think you have enough to get in front of a judge, but you're not going to see one for a couple of years, what happens? What does their status change? How do they just come into the United States, and what happens next? Like, what happens to those people?
They're given a date to show up and then kind of released into the interior of the country. Most of them end up hooking up with nonprofit organizations who will sort of help them stabilize. People are not eligible for work authorization unless they actually have an application that's been pending for a period of time. So for instance, if you're going to file an asylum application, you have to physically submit that application to the court or to Citizenship and Immigration Services and have it pending for at least 180 days for you to get work authorization. So when people first enter, they're not actually eligible to work yet, which I think is why we were seeing so much of a strain on a lot of resources, because you had so many people that were seeking asylum, intending to file asylum applications, but hadn't quite gotten that process started yet, so they didn't have permission to work.
So in practice, is what you see that, people come in, if they're not held, they get a date in a couple of years, and presumably the goal is to get themselves, hooked up with, whether it's a nonprofit or, an attorney that's paid for, by family or friends, and start the asylum application process immediately, because then that enables them to work?
Usually, if they know enough to do it.
Okay.
Many of these people have very limited education. Usually they don't speak English or speak only a limited amount of English. And we haven't done a very good job of notifying people about things like the fact that you have to file your asylum application within 1 year, or you might be deemed ineligible, how to do that, where to get a copy of the asylum application. So generally speaking, when people came into my court for the first time, they really had no idea how to do most of those things at all. And I was the one explaining them to them. Here's how you file this.
Even after a couple of years, they've been in so by the time they get to you, even still at that point, some people
haven't. It really kind of depends on how sophisticated the community is that they've landed in, and how many people who speak their language, who can inform them, who've been through the process themselves and know what's going on. In my experience, it's usually other speakers of the same language, other people who are from their home country, who are able to kind of step in and say, hey, you need to get this application filed. Here's how you do this.
Okay. And for the people who are not eligible for release right away, is there detention, is there a set period of time that you can only detain them for so long before you have a hearing? So if you come into the United States and you are assessed by an asylum officer, and they find that there is a credible threat enough that you're entitled to a hearing, what are the considerations as to who stays in custody versus who does not stay in custody?
So there are a couple of considerations historically. So someone who is an arriving alien, who presents themselves at a border crossing checkpoint, or who is apprehended right at the time that they cross the border illegally, are not entitled to bond in front of the immigration court. DHS can still choose to release them,
okay,
but they're not a mandatory hold.
Okay.
And they don't have the ability to ask to be released in front of the immigration court. Anyone who has certain serious convictions or arrests for certain kinds of crimes is a mandatory hold. So if you've been arrested for theft, for instance, you're a mandatory hold. If you have any sort of conviction for most violent crimes, you're a mandatory hold. You can't be released. So, but that usually, the decision for whether to hold someone or not is usually made by ICE,
Okay.
not by the immigration court.
Okay.
One of the controversies that's happening now is the question of when someone can ask for bond in front of an immigration court if they are detained and DHS doesn't want to release them. Historically, the term arriving alien or applicant for admission was deemed to mean someone who literally came to a border crossing checkpoint and asked to be let in, or someone who was apprehended right when they crossed the border.
Okay.
Last year, the administration changed that policy to define an applicant for admission as anyone who had ever come into the United States without permission. And so what that meant is over 90% of the people in immigration court suddenly were not eligible for a bond. This has been litigated extensively in the district courts, and the vast majority of the district courts have held that's an incorrect interpretation of the law. But we're still seeing a lot of fallout from this, with the administration pressuring the immigration judges, even with many district court orders, including 2 declaratory judgments saying, no, these people are eligible for a bond, pressuring the immigration judges to say, you need to find no jurisdiction.
It's really interesting and
so complicated.
Yes, it is. And that's why it's so important to have voices like yours who actually know how this works. So when you say that if somebody arrives at the border and there is a presumption if you have a conviction, for theft or any violent crimes, how are they able to how are we able to tell whether people have criminal records or not? I mean, I presume, I'm not an expert on international politics or law, but that how do we know what the records are of people, in other countries? And, presumably they're not quite as sufficient or efficient as, the United States. Here you run a border probation record, you have a III that, runs across the country. Is there a way to, when somebody comes across the border, is everybody having their record checked?
They're supposed to. They're supposed to get their fingerprints taken, and those are run against an FBI database. And most countries, at least within in the Americas, at least have some measure of information sharing with the FBI and provide those records to us. Not all, and obviously those records are not always complete. So there is always a distinct possibility that people are coming in who have a history of arrest or a history of convictions that we really don't know about, and they're not showing up on their background checks.
And that's, I think, some of the difficult part in, one of the many pieces of this puzzle that, best case scenario, we're able to fingerprint people, know who they are, know where they're coming from, if they have any history in the criminal justice system, but that there's a lot of people we can't, really assess whether they do or don't. And if we can't, is there sort of the same application for everybody, that, okay, if you come in, and we can't say based on our running of your fingerprints whether you do or don't have any criminal history, that they just kind of go into the regular process that we've been talking about, that you're released into the United States, you get a date in a couple of years, and there is a possibility that some of those people could have criminal records that we don't know about.
That's correct.
Okay.
There's a possibility. Yep.
Which I think is a fair, it's a fair critique of the
Right.
system, because if we can't otherwise ascertain whether somebody is, someone who's likely to abide with the, customs and rules and laws of the United States, should we be letting them
No,
in?
absolutely. I think that's a real foreign policy consideration that is something that really should be and could be improved on, is better information sharing with other countries in the Americas in particular, where we're getting a lot of our immigrants from, but also other countries as well. We have a number of people from other countries who will fly into Central American nations, especially Panama, and then make their way north and cross into the United States from Mexico. So a number of Chinese nationals from India and things like that. And we don't have great information sharing with those countries, and often don't really have any idea who these people are.
And in many ways, we're just sort of letting them in anyway.
Yeah, it is true. I do think that usually people who are not detained, by the time you have a merits hearing on their application, because they've been here for so long, you generally have a pretty good idea of who they are as a person, because they have been here for a long time. So I think pretty quickly you start to see sort of a divide between people who tend to have a history of assaults, who might have DUIs, who have repeated theft offenses, who have documented gang involvement, versus people who are really just trying to live their lives and don't get into trouble. But that can take some time to sort of figure out.
Yeah, and it working in the criminal system, and I think it's a very real. It's unfortunate, because it's a really difficult topic, immigration. There hasn't been a lot of reform, as we were discussing beforehand. And it's become so hyper political that we don't really think about, like, okay, look, what's actually happening. And, as somebody who has been in, practicing in Massachusetts for a long time, there quite frankly is a fair amount of, real crime within many immigrant communities. And it's hard, because you don't want those individuals to, negatively impact the people who are, truly trying to escape someplace else, coming here, working, trying to do the best. And so it's difficult, because it seems like the way our system is set up, everybody is sort of kind of lumped together until we can figure it out. But in that process, a lot of people are entering the United States. And that's certainly not to say that, everybody who's coming here has a criminal record or is going to be committing crimes, because that's clearly not the case. But I think it's a fair critique for those who say, like, wait a second, well, isn't there some sort of stopgap that we can figure this out? So from your perspective, when if you arrive at the border here, you essentially have really two pathways. You're either evaluated right away and someone says you're gone, you're not coming in, and then you get a hearing and then you're deported, or you fit sort of the general asylum requirements, you come in to the United States, and then down the road you'll get a hearing. Am I understanding that?
Sort of. If you don't assert a fear of persecution or torture, there's no hearing. They're just removed.
Okay.
If you do assert a fear of persecution or torture, but the asylum officer and then the immigration judge decide that that doesn't qualify, you don't get a hearing, because those are really just interviews. They're quick. They're usually less than an hour, and they don't have the full scope of sort of what we would consider due process protections of a full hearing. And in my experience, I have to say, asylum officers, they're not necessarily attorneys. And I think most of them do their best, but they're not necessarily always asking the right questions. So let's say you have someone, for instance, who came to the United States because they were subjected to really, really severe abuse because they were gay. They're often detained when these proceedings are going on in the interview. They don't necessarily know who the interpreter is. The interpreter is usually on the phone. They don't have an attorney. They're often very afraid to disclose what happened to them because of internalized shame, because they don't know who else in the facility might learn that they're gay or trans. So the asylum officers aren't necessarily trained enough to be able to solicit that information. And they're doing many of these a day, 10, 20, sometimes a day.
Right.
So it can be really difficult.
And in these asylum officers, they're actually at essentially like at the border station. So within, like the
Sometimes.
Okay.
Mostly they're calling in.
Oh, interesting. So they're not even seeing
not
people
even
in
there.
person.
Right.
Which I have to tell you, I know that post-COVID, everybody loves Zoom. Everybody loves all this stuff. I think there's a real detriment to not having a lot of, especially legal issues and conversations, things like this, not having them in person.
Especially when credibility is an issue.
Right.
When you need to see the
somebody.
person, you
Right.
want to observe their facial feature, like their interactions, how they move when they're responding to questions.
That's really interesting.
It's not a science, obviously. It's very imperfect. And different cultures, when they're nervous or when they're trying to be deferential, will behave in different kinds of ways that we as Americans might interpret as being evasive.
Right.
When they're just trying to be respectful. But I think it's really important to have that face-to-face engagement.
And so the asylum court officers, are there some who are attorneys?
Oh, yes, absolutely.
Okay.
Yeah, but it's not mandated that
Okay.
they be attorneys.
And probably just because the system is so overloaded, there's just not enough of them, just as there aren't enough, judges.
Right.
And,
There's not enough of anybody, I'll be honest. The immigration system has suffered just as much as I think the rest of the federal government of being underfunded for, at this point, decades. And unfortunately, as the immigration needs have ballooned, the amount of funding that's been going to it has not. The one exception recently has been ICE, obviously,
Right.
which now has a huge budget.
Right. But none of that goes to.
But that's not going to the courts.
Right.
And
Which
that's
is
not going to
really who needs the,
Right. I would say Citizenship and Immigration Services, which is part of DHS, but kind of a sister component to ICE. They need a lot of funding, and the court system needs a lot of funding. Citizenship and Immigration Services are the ones who process affirmative applications. So let's say you are married to someone who lives abroad.
Yep.
You want to file for them to come to the United States. You would file what's called an I-130 petition, and it's Citizenship and Immigration Services that would adjudicate that.
Okay.
But there's huge wait lists for those in part because they're so backlogged.
And so it seems sort of doesn't really make a lot of sense to put so much money towards enforcement when you don't have a court system that's capable of managing them all. I mean, as it is,
Right.
Never mind with more people coming into the system. Can I ask? We hear a lot about this temporary protected status and what that means for people who have it. Can you tell me what does that actually mean, and how do you get that status?
Sure. So temporary protected status is something that can be announced by the administration. There's a whole regulatory process for how to do it and determine that different countries might warrant TPS. And it's designed to protect people who are already in the United States from being removed because of some situation that has occurred or is ongoing in their country. So, for instance, in the 1990s, temporary protective status was provided to a number of countries that were impacted by really severe hurricanes or volcanic events that caused economic devastation. Haiti had TPS after the earthquake and the cholera epidemic. So it's been routinely used since at least the 1990s to provide a temporary stay, ideally a temporary stay for people who are already here. In order to get that TPS, you have to have already been in the country at the time that it was announced. And it does allow people to get work authorization.
Okay.
And it doesn't provide them any pathway to permanent residency or citizenship, but it does allow them to stay here.
Okay.
I think where a lot of the frustration or confusion has come in is that when TPS is rescinded, it's supposed to be after sort of a reasoned process to make sure that that country is now safe for people to return to. And what's occurred, unfortunately, I think last year and this year, is that TPS has kind of been cut off across the board without doing that sort of reasoned examination, and for people who have been in this country for 20 or 30 years.
Right.
And I think it's been frustrating for a lot of folks who have bought houses, their kids have been born here, they're U.S. citizens, they might own businesses, and to kind of just have to append all of that and return to a country that still is not recovered from whatever the issue was or is still in dire straits. I mean, Haiti has no functioning government for all intents and purposes.
Right.
So I think that's that's caused a lot of frustration for people who feel like they did everything right.
And so what that means is essentially that anyone who had protected status was not eligible to be picked up by ICE.
Well, technically speaking, they could be.
Okay.
Nothing about TPS prevents you from getting a removal order.
Okay.
They just couldn't enforce the removal order.
Okay. Interesting.
Yeah.
So, for example, like if somebody committed a really serious crime and they had protected status and then they committed a crime, served, was sentenced, served, and then came out, they would be eligible for deportation, but wouldn't be because of their protected status.
Well, in that situation, TPS can be rescinded.
Okay.
If you've been convicted of certain crimes.
Okay. And do we, if that is the case and it's rescinded and then a deportation order is issued, do we send people back to the countries where we have granted them TPS status
Sometimes.
from, or do we send them someplace else? Or
That's an interesting question. So it depends. There are some countries who for a long time either were refusing to take their repatriated citizens or just didn't have the logistical infrastructure to be able to take them.
Okay.
Like, for instance, for a long time, we were no longer doing repatriation flights to Haiti because every time we tried to land an airport at Port-au-Prince, they would get shot at.
Yeah. Right.
So
Not helpful.
Not helpful,
Yeah.
right? Really makes it difficult.
Yeah.
So it is possible to remove someone to another country historically, but it was very difficult because you had to get permission from that other country to do it. It was sort of a diplomatic nightmare. Usually we didn't bother. So people would kind of remain in the United States for a long period of time. Especially that was happening for decades with a number of people from Vietnam.
Okay.
Because for a long time, until very recently, Vietnam was not accepting most repatriation of their citizens. So you had a large number of people from Vietnam who had removal orders but could never be removed. So they were just sort of remaining here in the United States. Now, that's sort of shifted recently. The Trump administration has implemented a lot of agreements with other countries, usually in exchange for certain financial considerations or preferred trading partner status. To accept citizens from other countries as part of the repatriation process. Of course, that's opened up a whole other can of worms.
Right.
So-
And that's it is one of those that the Supermax prison that we've heard a lot about, that there's been sort of an agreement between, and I don't know that we're still sending people there, but in the beginning of last year, that there was some sort of financial considerations back and forth, and that we were just sending many of the people who had final deportation orders, not necessarily to their home countries, but to this other. I mean, is that unprecedented that we would send people to a prison in another country?
Yes.
Okay. Because
Yes.
I mean, on its face, to me, that just seemed like I'm confused about what authority do we have? I understanding that if somebody's here illegally, we have the ability to issue a final deportation order and deport them. But what authority do we have to send them to a prison in another country?
And the answer is really none. So immigration, I think this is something that kind of confuses a lot of people. Immigration does have criminal components to it. If someone crosses the border illegally and they're caught doing it, they can be convicted for a misdemeanor. That is an offense.
Yeah.
A felony in certain instances.
Okay.
So there is a criminal component to this. Certain crimes will render you removable even if you have a green card. But by and large, for the most part, immigration is a civil matter or an administrative matter. It doesn't come with jail time or penalties. People can be detained, but that's not intended to be a punishment. It's meant to hold them temporarily so that we know where they are so that we can effectuate their removal. So removing someone and having them be held in custody in another country at our request is really unusual. I don't think that's ever happened before.
Yeah, I don't think so either.
So,
Okay, so let me ask. We are hearing a lot about people who, as we kind of sort of transition into what's actually going on the ground now. We hear a lot about people who are, it seems to be in the process, going to the immigration court hearings and sometimes being apprehended. Are those people the individuals who have seen the asylum officer come through, have a hearing in 3-4 years? Are those the people who are checking in periodically with the immigration courts? Like, so is that when you get a date in 2029, are you required to come in set amount of times to check in, or you don't even get into the system until 2029?
So there's two things that are going on. Okay. So usually when people cross in and are put into removal proceedings, they have court dates that they do have to attend. If you don't attend a court date, you can be ordered removed in your absence. The other thing they usually have are called ICE check-ins, where every 6 months to a year, sometimes even more frequently, they have to go to an ICE office or check in on an app within their phone that shows their location and where they are. Or sometimes they call into an ICE office, but they have to have some engagement with ICE to make
Almost
sure.
kind of like a probation, conditions of release type
very
of
similar
thing, where they just, the government wants to make sure you are where you say you are. You're sort of in the cog of, you know.
They check your address, they check who you're living with, they see if you're employed, very sort of basic biographical questions. So usually those two things are happening at the same time. Someone will have removal proceedings where they have hearings at the court, and then they'll also have ICE check-ins. People are getting detained at both. Usually it's not necessarily being... when we were seeing the people getting picked up at their court hearings, it wasn't necessarily their final trial dates. It was usually those master calendar hearings where they were coming in and getting a date set for their merits hearing or submitting an application for relief or taking pleadings. It was usually then that people were getting picked up. And I think to some extent that's because of simple logistics. If ICE has a quota and they have a certain number of people to pick up, it's better to do a master calendar hearing when there's going to be 20, 30, or 40 people there.
When you know they're going to be there.
When you know they're going to be there, as opposed to a merits hearing where you're probably only going to have like a family.
And so... do you think that scares a lot of people into going to, it's a really, it puts people sort of in this conundrum of, I'm in the process, I'm doing everything I'm supposed to, I am told to come check in, I want to go check in, or I want to, whatever stage of the process that you're at, and that, so those people, like in other administrations, was this happening?
No.
It wasn't at all. Okay. No. So, whether it was, so essentially it's always been sort of the accepted practice that if you were going through the process and you were doing everything you were supposed to, checking in, had your date, otherwise complying, it essentially protected you from being picked up for the most part.
Right. The only situation usually in which someone would be picked up is if they actually got a removal order or they committed some sort of crime. Okay.
And so it puts people who are in the system and in the sort of waiting into that must be a difficult, what do I do? Do I go and check in? I'm afraid to go check in because I'm concerned they're going to pick me up, but I want to comply. And so now that ICE is taking those people, what is the process now different? So because we have sort of accepted, through multiple Republican, Democratic administrations that if you go through this process, if you check in, you'll get to a hearing eventually, and then it'll be adjudicated on the merits. Now that we're detaining those people before they ever have their hearing on the merits, what's happening to what is the what's the mechanism by which they're detaining them? Because the goal is to what? Just immediately deport them, or what is that? What are they actually doing?
So usually, I think what's supposed to be happening is it's just supposed to sort of expedite the process. I think that was perhaps the original intention, because detained cases do proceed much quicker, usually on the order of months rather than years.
Okay.
So I think best case interpretation, you can say that the intention was to speed these cases up. The problem is, of course, then you run into the same issue that the immigration courts have in general, which there's not enough judges, there's not enough court staff, there's not enough OPLA attorneys with DHS to handle an increased volume. So what has kind of been occurring over the past year is the administration has been issuing new decisions that pretty much make it difficult to get to that final merits hearing. So what we're seeing now is people are having their asylum applications pretermitted, which is sort of a legal term of art. It means their applications are being denied without a hearing.
Okay.
And that's mostly because of two things. First, the administration, the Board of Immigration Appeals issued a decision saying that if an asylum application is not complete, it can be pretermitted, meaning every single thing has to be filled out with the full facts of the case. Now, historically, especially with pro se respondents, that was not necessarily required. As long as you kind of submitted an application with supplemental documents or an affidavit, or you kind of put sort
You
of a
make a
bare
good
bones,
faith
you make a good
basis
faith
to-
effort. They didn't require a prima facie showing of eligibility on the application.
Okay.
But that shifted sort of the middle to end of last year. This board decision came out saying immigration judges can pretermit if the asylum application doesn't make out a prima facie showing at the time that it's submitted. And so after that, we saw sort of a slew of motions to pretermit for cases sometimes that had been pending for years, because the application didn't have a prima facie claim on it. The other thing that we've seen is what are called asylum cooperative agreements be implemented. And that's these agreements that the Trump administration has entered into with foreign countries where they agree to take folks, ostensibly give them an asylum hearing in that country, and then we don't hear their case. So for instance, right now, folks who are immigrants from Africa are having their asylum applications pretermitted under the theory that they can just be removed to Uganda, and Uganda will hear their asylum claim
For the United States.
for the United States.
And,
but
theoretically, they could get back, but we know that's not
it's not
likely.
Right, exactly. And this has caused a lot of confusion, in part because not all of the asylum cooperative agreements are clear exactly with respect to who exactly is being taken. There have been cases where someone's had their asylum application pretermitted, saying, you can be sent to, for instance, Ecuador and have Ecuador hear your case, but then they end up getting sent to their home country anyway, that they supposedly at least fear persecution and torture in.
Right.
We're finding out that some of these countries aren't actually even adjudicating these asylum cases. They don't have the capacity to do it. And then, of course, we're having issues where some people are fearing persecution or torture in these third countries that they're getting removed to, but they're not being given an adequate opportunity to put forth that claim in front of a judge.
So like in theory, you could be, here for 10 years, 15 years, 5 years, whatever amount of time in the process, checking in, all this kind of stuff. If you didn't do something technically on the application, that could be grounds for a judge essentially saying, okay, we're denying the application, and when we pick you up, we're putting you on a plane to Uganda or Ecuador?
The asylum cooperative agreements apply even if you didn't do anything wrong at all. Even if the application is complete, even if it's thoroughly submitted, bolstered with evidence, even if you have 100 witnesses that all attest to the fact that you were tortured by your government, it doesn't matter. You can still have that application pretermitted.
And so is it fair for me to say that, or at least how it feels to me, that the rules within the immigration court come from the administration versus, it's a very different idea of the law than how I see it, that you would think there would be some sort of, you would think there'd be rules on, this, if this is what the statute says, if this person complies with this, you get A, B, and C. If they don't, you get D, E, and F. But that it's pretty malleable depending on who's in office?
Well, I think this is sort of a challenge that the immigration court system has because it's not an independent judiciary. Right now, there's lawsuits in place saying that these sort of administration regulations or these interpretations are not legally valid.
Right.
There is a statute that says that the administration does have the authority to remove people to safe third countries. But there's really an open question about whether countries like Ecuador or Uganda or El Salvador are safe. And
It's a fair question.
I think that's a fair question too. The other issue that I think is coming up is that when you file an application for asylum, we sort of colloquially say asylum, but there's actually 3 types of relief that are included within that application.
Okay.
One is asylum that does give you, if you're granted asylum, your spouse and children can get it as well. It gives you the ability to apply for a green card within 1 year and ultimately gives you a path to citizenship.
Okay.
But there's 2 other forms of relief as well that go along with that application. One is called withholding of removal.
Okay.
Where technically speaking, you have a removal order. We're just not going to remove you to that country where you feared persecution or torture.
Okay.
The other is called convention under the Convention for the Protection. All right, I'm really screwing this one up.
It's about torture.
Yes.
Yeah, I know.
Colloquially,
I
the
know
torture
third
convention.
box
I'm like,
somewhere,
what's
torture-
the
yeah.
official word?
Yeah.
So, yeah, it's the torture convention where basically if you can prove that you would more likely than not be tortured by the government in your country or with their acquiescence, then we won't remove you to your country either.
Okay.
And those are treaty obligations. We're required under 2 different treaties that we have signed and ratified to provide that relief to people. There's nothing in the statutory language that permits pretermission of those for a safe third country, but the regulations allow for pretermission of those as well, and those are getting pretermitted by the immigration judges now. So I think there's a real question about whether that's violating our treaty obligations, which in turn would be unconstitutional.
And do you think that so when this sort of I don't know if you call it a mandate or directive comes down that this is okay, we're not doing it the same way that we used to. This is what we're doing instead. Do judges actually have the ability to, is this really a directive, or can judges say like, okay, I understand those are the guidelines, but like I'll make my individual decisions based on each case? Or do you feel like this is really a mandate, and if you don't follow it, you're going to be out of a job?
So that's kind of something that I think a lot of immigration judges right now are struggling with. There are certain things like, attorney general decisions. If they come down through the proper course and, officially issued decisions, then yes, that's now considered the new interpretation of the law. You're obligated to follow it, just like any judge would be required to follow decisions by a higher court.
Right.
But if it's policy directives, internal memoranda, or emails, then there's kind of a question about how does this conflict with my reasoned interpretation of the law and my duty to uphold the law and to uphold the Constitution? And I think that's where some judges are running into problems, especially where, right now you've got the administration who a couple of weeks ago they sent emails from the chief immigration judge's office telling judges to ignore district court orders that issue declaratory judgments for bond. And
Right.
the judges were told to ignore it. And according to reports from practitioners, several judges around the country who continued to grant bonds anyway, saying, no, this is a separation of powers issue.
Right.
I'm obligated to apply the district court order, have been removed from those dockets. So, and we've seen a number of immigration judges around the country who have been terminated, over 100 judges.
So I saw as I don't know if it was NPR was keeping sort of their own internal tally, and that's what they said that by I have seen the 100+ number, and that by their counts there was somewhere in they thought it was closer to even 140, and that didn't even include all of the individuals who had voluntarily resigned or
Were retired,
retired. And I think it's obviously there's with any change in any administration, whatever department you're in, there's always going to be switching over of people in charge, who leads the department, things like that. But this seems rather unprecedented.
This is unprecedented.
Yeah.
So immigration judges are career civil servants. They are supposed to have a 2-year probationary period, and at the end of the probationary period, if they make it through that probationary period, they're supposed, generally speaking, you retire from the job.
Right.
This isn't a
Right.
job where people leave.
I mean, and I think that's as attorneys, when you reach the point to, okay, I've worked my whole life in in this area, and now I finally sort of reached the pinnacle of getting on the bench. I think the expectation is across the board that that's going to be the last job you have. You're going to stay in that position until you're ready to retire. And so the fact that we see all of these firings and resignations, I mean, what does that tell you?
Well, personally, I think the terminations are really frightening. Even those that were done at the end of the probationary periods, usually if a judge was fired at the end of their probationary period, with a couple of exceptions here and there, it was because there was a good reason for it. The firing of immigration judges outside the probationary period with no sort of internal investigation, no progressive series of disciplinary measures. Just one day you're on the bench on a Friday afternoon and you get an email saying, turn in your badge, you're done, has never happened before. That's never happened before. I can't, it's difficult to find the words to impress how
Concerning
utterly spectacular and strange that is that that's occurring. and usually without any forewarning. Like, it's not as if the judges have been called in to speak to their supervisors.
Right.
There had been no prior complaints against most of the judges. It just kind of came out of nowhere.
And do you, I suppose anecdotally, do you find that the individuals who were sort of, I don't want to say targeted, but targeted for firing, were they ones where the statistics weren't sort of in line with the administration wanted, or so basically they want people who are going to do what they tell them?
Most of the people, not all of them, but most of the people who were let go before becoming judges either had fell into one of two categories. Either they typically had grant rates of about 70%.
Okay.
The national average is, I think, around 45.
Okay.
Or they were from nonprofit or private practice backgrounds.
Interesting. So they have probably worked with, on the other side of things. So for people who don't know, so that would mean, as opposed to your experience where you worked for the government,
Exactly.
for your whole entire career, that many immigration judges, well, I don't know if I should say many because I don't know, to be clear, but immigration judges who came from a background of representing the
immigrants.
respondents and things like that. So those seem to be more of the targeted judges for firing.
Yes, though not everyone falls into even one of those two categories. So some people have been terminated without any apparent reason.
So it must be a really difficult environment to be working in, on top of the fact that you have this enormous backlog of cases. You have this, extreme level of enforcement that's bringing more in, and that at any given day, if you maybe say or do something to make the wrong decision, I mean, your entire career is altered in a second. And and I think the whole purpose of maintaining an independent judiciary is to avoid that,
just that.
I mean, it's really interesting from looking from the inside out that I'm starting to think, like, is there a way that we can, obviously there's so much reform that is needed, but to me, I think as a judge, you need to be able to make a decision and know that nothing's going to affect it. You're not going to lose your job because it's unpopular. You're not going to feel like, I have to lean this way because I might lose my job. I mean, that's the opposite of what we want.
Yeah,
Judges,
I would say one of the best reforms that we could make would be to make the immigration court an independent Article III judiciary court.
It's really
Similar to the bankruptcy courts.
Right. And am I correct in that the immigration judges are the only type of judges that don't fall under as part of the judiciary?
Well, there are plenty of administrative judges throughout other agencies. In fact, most agencies have some sort of internal either hearing officer or judge that hears administrative matters or civil matters that are overseen by that agency. I think, though, the immigration judges are a little bit unique in the nature of the cases that are being heard, because these aren't simply a situation where the wrong result gets the wrong person fined.
Right. I mean, these are substantial
issues.
Yeah.
And
life or death, really,
right.
for many people.
And, it's interesting because back when the immigration judges had a union, which was disbanded by the prior Trump administration, one of the leaders of the immigration judges union actually had a quip that I think is really appropriate. I think it was Dana Lee Marks. She referred to immigration court as death penalty cases in traffic court conditions.
That's actually really interesting. You're right, because to me it seems like these are really important issues. I mean, these are people's, whatever you think about immigration or whatever side of the political spectrum you're on, these are people's lives, and these are people who are going in front of, a foreign system and basically saying, please help. And a lot of it seems like willy-nilly, in that we're not sort of giving it the deference that it needs. I mean, even the fact, the amount of backlog, how are you really able to truly adjudicate these cases when you constantly behind you in the back of your head, well, I have this one, I have this one, I have this one. I mean, you're never going to catch up, and you can't really spend the amount of time necessary in an ideal world. And not that you would be able to, if even with reform, but
it is really difficult, and these cases do require a lot of attention to them. The evidentiary packets are voluminous. They require a really sophisticated understanding of country conditions around the entire world. Because we might have. When I left the bench, we were required to do at least 3 asylum hearings a day.
Okay.
Now the judges are under direction to do at least 4. That's a lot.
It's a lot.
That's a lot. And so,
And is that you 5 days a week?
except for when you have master calendar hearings, yeah, you're
Yeah.
in court all the time. You don't necessarily have, if you have any sort of office time where you're doing your motions practices or writing decisions,
Yep.
then that's a luxury. And
Well, and that's what I was going to ask. So is it that you're on the bench for the most part 5 days a week, and then on top of it, you have to write all your decisions, and so there's no really even consideration for that sort of structured within the work week.
right, and
It's not like you have 2 days to write your decisions, 3
No.
days on the bench.
No, not at all. You're in court 5 days a week. Even when somebody has sort of in chambers time to work, it might be one morning or one afternoon. It's not a full day. Even.
And you're never going to get all those.
And you're never
right.
getting it right. So my typical day when I was still on the bench is I would be at the court by 7:30 in the morning. My first hearing was at 8:30. I would use that hour to basically prep the cases that I had for the day, which often was the first time that I had a chance to look at them.
Right.
And
Well,
so
because how could you?
How could you?
How can you possibly prep?
Yeah.
When you have, because the day before you have the same thing, and the day before,
Exactly.
and the day before, and the day before.
So any breaks that I had, if a case got continued, I would take that time and I'd be working on motions. I'd work through lunch. People weren't leaving until 5, 6, 7 o'clock at night some days. And just, to kind of put that in perspective, they turn the AC off at 5 o'clock, like the building shuts
Right,
down.
right,
so
right.
so you're sitting there in like this quiet building. Most of the staff have gone home and you're still working.
Yeah. And do you find that, sort of on a personal level, did you struggle with that you're required to make these very serious decisions that, really are, affecting people's lives, and that you just don't have the time that in an ideal world,
Yeah.
you would like a lot more time so that, you feel as comfortable with your decision as possible? I mean, is that sort of a difficult push and pull within the system?
Yeah, it is. And, one thing that I would often tell new immigration judges or new ICE attorneys when they were coming on board is I don't know a single person who's in the system that doesn't eventually get secondary traumatic stress disorder at some point. Just because the volume of the work, the things that you're hearing day in and day out, because even when people can't get a grant of asylum, it's not usually because they didn't experience something. It's because what they experienced doesn't fall into the legal parameters of what an
Okay.
asylum claim constitutes. So to get asylum, for instance, you have to show that you were persecuted or have a fear of persecution in the future based on your race, religion, national origin, political opinion, or what's called your membership in a particular social group, which means you have to share a trait with other people in society, and society sees you as being distinct in some way. Okay? So people, for instance, who were being beaten up or having their children killed by gangs because they weren't paying extortion money, that's not an asylum claim. Folks who were being targeted because they were in a community that was fighting back against narco traffickers, that's not an asylum claim. So,
Which is really interesting, because it's like, you look at sort of the international political landscape is like, okay, on one hand we're saying, we're going in again in Maduro and saying the narco trafficking, and then on the other hand we're saying, well, that's not really enough for you to be, it
Right.
seems incongruent with each other, and it's really quite interesting. So those people, so say you come from a country and your kids, your family's being attacked because you're not paying extortion money, things like that. Are those the situations where you would not technically qualify, but then you'd have a deportation order, but what was the word that you used, that it wouldn't be enforced?
oh, like with TPS or something?
Or the withholding?
Withholding? No, withholding, you have to meet those same requirements. In fact, it's even harder. With asylum, you have to show what's called a well-founded fear, which means a reasonable person in your situation would fear being persecuted on account of one of those grounds. For withholding, you have to show you would more likely than not be persecuted.
Okay.
Withholding really comes in if someone usually didn't file their asylum application within 1 year. They're no longer eligible for asylum. They can only get withholding. Or if they have certain kinds of convictions that would render them ineligible for asylum, but aren't so severe that we're not willing to give them withholding. But I think what's important to kind of understand about these sort of grounds for how to get asylum and withholding is that when people point to these statistics that say, 60% of people's asylum claims are unsuccessful, they're just economic migrants, I feel like people need to take a step back and say, just because it's not an asylum claim, it doesn't mean they're not legitimately afraid.
Right.
So people can have experienced some horrible, horrible things and not be eligible for asylum. That's the way the law works.
And so for those people, the asylum gets denied and then
They're removed.
and then they're removed. Okay.
Yep.
And mostly back to their country, unless it's a country that is you would get temporary protected status from.
Correct.
Okay. So you could not be eligible for asylum, but if you came from someplace like Haiti and as an administration, has declared that, okay, we're not going to send anybody back to Haiti.
And you were here at the time the TPS was issued.
Okay.
Then yes.
And so then you can stay here.
Yep.
And so you're just sort of like lingering forever in the country. I mean, it's just sort of.
Yeah, you're sort of in limbo.
Forever.
You're sort of in limbo. Sometimes there are a few rare instances where someone with TPS could potentially get a lawful means to stay here. So, for instance, for a while, if you asked for something called advance permission to return, and you had married a U.S. citizen or you had a U.S. citizen relative who could sponsor you, then you could get those applications approved, leave the United States briefly, like to Canada or something, come back, and be able to get your green card. But that's really rare and not very common. Generally speaking, most people who have TPS have no way to ultimately get a green card, which I think is something also Americans don't understand by and large, because we have this idea in our minds of sort of the Ellis Island system, where there's a list and you follow these steps, procedures, and you can come here legally and then eventually get citizenship and you're fine.
Right.
By and large, I would say over 99% of the world will never qualify for a green card to the United States because they don't have a business who's willing to sponsor them or an immediate family member who's sponsoring them. The only people who can sponsor an immigrant are their spouse, their parent, or a child can sponsor their parent if that child is over 21.
Interesting. Okay.
You can also do brothers and sisters, but the wait for that is over 20 years for most countries. So generally speaking, if you don't fall into one of those two categories, you're not getting a green card. The only other way really is called the diversity lottery, which I think you have a better chance of winning the actual lottery than the diversity lottery.
Lotteries are never good. It's like, okay. So let me sort of transition a little bit. I mean, that's really, and I know that we could sit here all day because the amount of information and the amount of sort of knowledge you need to really understand this is so voluminous. But I think that really just sort of gives me a baseline of, who's here, what is the process. Let me ask, are there, or do we know how many people, like are there a certain amount of people that we think come in and then never sort of take the next step and go through, they don't show up for their hearing in 2029 and they don't put in an actual application for asylum? Are those people, are there a lot of those people, or do you think that most people come in are in the system?
Most people show up for their hearings.
So it's almost, it sometimes feels like there is a feeling in the country that people are not compliant. You hear a lot of like, well, come in the way my grandparents did. And I'm like, well, I don't know. I think they kind of are. They're showing up at the border and they're following what the United States says are the rules. Maybe we disagree with the rules and we change those. But I'm not sure it's all that different from, my Irish great-grandparents coming in who didn't have much and probably had IDs and, got checked and then came in. And went through the process. So if we think about sort of what's happening today, when we had a conversation on the phone before we decided to do all this, you said something that it really made an impact on me, particularly because, you were appointed to the bench in 2021. And as we've talked about, I think being a judge is such an honor. And I think that having the ability to take people's lives and everything that, comes from it into your hands and make the decisions, it's really one that I think only people who have the right temperament should have. And I think it's an honor when you're appointed to the bench, and particularly in a field in which you've practiced for a very long time. I don't have any sort of designs on getting on the bench, but I just think about what an honor it really is. It's for lawyers, it's really the epitome in many ways of, hard work. And you said to me that you felt you had to resign because you were concerned about having to violate your oath to the Constitution, and that it really was more a moral decision for you.
Yes.
And, that really stuck out to me because as one of my most favorite quotes, the late Robert Kennedy said, "Moral courage is a rarer commodity than bravery in battle." And I think we are living in a political time where a lot of people are not morally courageous. And, to leave the bench and to leave, sort of a career in which you thought you would retire out of, I think takes a lot of guts. And it really stood out to me. And can you tell us a little bit about what prompted that and what sort of the internal, thoughts you went through before? I mean, because it's a big decision. It's a life-altering decision that you made voluntarily because you swore an oath to the Constitution. I don't think that should be understated. So I'd love to hear about sort of how that process went for you.
It was something that I struggled with. As difficult as the job was, I really loved the job. And I loved the people that I work with. I have a great deal of respect for everyone in that court who comes in every day and works in really, really difficult situations, especially with what was going on at the time. And in May 2025, you have to remember we had just gone through the Doge process.
Right.
And Russ Vought had made a comment that his goal was to traumatize the federal workforce, and I think he succeeded. But part of me thought I want to stay and continue to kind of apply and uphold the law. I think it's very important that no matter what administration is in the office, that the law is being upheld, right, and that the Constitution is being maintained, and the integrity of the court system and the integrity of the expectation of due process is there. There were just a series of things that were happening internally with the agency that made me realize that the judges were going to be put into an impossible situation where they were going to be asked to either violate their oath to the Constitution or violate the directives of the agency. And I think, unfortunately, that has sort of panned out, that I was probably right to leave when I did. The final thing that made me decide that I needed to leave was my supervisor had informed all of us that, they had anticipated a lot more people being in detention.
Okay.
And so we were told that we were going to be expected to sign what are called stipulated removal orders, okay, where someone, and this already exists, this is the thing that happens, where someone who's in detention in particular says, I don't want to fight my case, I don't want voluntary departure, I don't want asylum, just get me out of here, I want a removal.
Okay.
Ordinarily that happens, though, in a process where they're in front of the judge, and the judge is able to ask them, do you understand you're giving up your right to apply for asylum? Do you understand that you're giving up your right to voluntary depart? Are you making this decision knowingly and willingly? Is anybody coercing you into this decision? Right. And I asked my supervisor, she was saying that we were expecting as much as 10 to 20 of these a week, and that we needed to sign them and get them out as soon as possible. Once you get that stipulated removal request, sign it, get it out, get that person removed. And I asked her, well, can I at least pull these people in for a quick hearing, 5 minutes, right, just so I can make sure this is what they right want, especially since these people, as I've said before, many of them are not literate. Even if they are literate in their native language, they don't speak English. Right. They don't read or write English. Right. They may or may not have an attorney. They don't understand the U.S. legal system. So I asked her, can I just, quick hearing, call them in? And she said, that's not going to be possible. And that was the point at which I was like, this is my line. Yeah. This is my line. I can't order somebody removed without knowing for sure that that's what they want until they've been through the process.
Well, and I think too, this, you talk about this knowingly, voluntarily, it's something that is drilled into us in the criminal system that, you don't do anything really until you ask the person in front of you. And like we said, why it's so important to have somebody physically in front of you to say, this is what's happening. Do you understand? Have you been pressured? Have you been, are you sure you're doing this? You know what you're doing? You're willing to do this? Okay. And that's fine. And so you think about the fact that your request was, can I just get them in front of me and ask them those questions? And if I feel comfortable, I'll sign it. And the answer was no. Mm-hmm. I mean, it's some of the stuff that happened is so concerning to me that it's I almost don't have words for it, because that's sort of the fundamentals of the judicial system is like notice an opportunity to be heard, right? Like that at the very least, we are entitled in America to go before an independent arbiter and say, this is my case. No, because you think about, particularly with the way enforcement is going in this administration. I mean, I don't know how we could trust that anybody is voluntarily signing these things, because we just have, so would it look like somebody's picked up and then the ICE agents say, oh, he signed so-and-so, or he said he's willingly going to, what was the name of the word? Stipulation. And you're just supposed to adopt it, essentially.
That was my understanding.
Rubber stamp it,
yes,
really.
that essentially, they would get a signed statement. That whoever was in charge of the detention facility, ICE or some other entity, would get a signed statement from the detainee saying, I want to be removed. I'm giving up all rights to relief. I'm waiving appeal, et cetera, et cetera. And once that was submitted to the court, I was expected to sign a removal order.
And there's really no way to otherwise, without a hearing and without a judge asking those questions directly to somebody, there's really no way to confirm that this person actually understands what's going on.
Or even signed it.
Yeah, right.
So, yeah.
Right. And I think because of, it's almost like at every step of the process, as I see it now, is this sort of erosion of the fundamentals of the system. And, now that we look at how enforcement is being enacted, how can we trust that this is actually,
yes.
And I'm so, it's difficult for me because I always try to say, like, listen, I'm somebody who's very, I'm often defensive of law enforcement, because I think that unless you're in sort of the worlds of the criminal justice system and law enforcement, there's a lot of factors that maybe lay people don't take into consideration, and, what's happening on the ground. But I just think objectively what's happening now is we seem to be operating in a system where the rules don't apply anymore.
No, I completely agree. I have no problem with enforcement.
Right.
I do have a problem with erosion of the law. And I think what you say is completely true. And one thing that I think is often getting lost in this conversation too is how, speaking about, viewing things from the perspective of law enforcement, how difficult this is also for, and I'm going to get flack for this, for the ICE agents.
Sure.
Many of whom signed up in prior administrations in particular because they were concerned about child trafficking.
Right.
They were concerned about gang violence. They were concerned about drug trafficking. International crime syndicates or foreign intelligence operatives coming into the country. And right now what we're seeing with this quota system is they're being pulled off of really important essential investigations to go pick up people's grandmas while they're grocery shopping.
Right.
Which they don't want to be doing.
Right. And that puts, and you think about, because obviously we have sort of this influx of new agents, and then you have people who have been in the system for a long time. And I'm sure there is just as you had this internal struggle, but you look at somebody who, if you've been federal law enforcement for a long time, whether you're ICE, whether you're CBP, anything like that, and you're an officer who, believes in the Constitution, that it should apply across the board, that, you have spent your career really dedicated to making sure that people are safe. What do you do now? And I think the implications have to be considered that, these people have pensions. They have, you can't just like, oh, well, it's difficult if you've been in the system for a long time. Like this is your life plan, right? So what do I do now? I can't stand up vocally. I can't, I think it just puts the good guys who are within the system really at a disadvantage because the bad apples seem to be running the show, and so it has just completely gutted any faith that many of us have in the system as a whole. How can we trust anything anymore when we see, I'd like to get your thoughts on this idea that there's a 3,000 arrest quota coming from Stephen Miller. Like, how is that valid? We know that quotas are
never a good idea
of what good law enforcement is.
Right, it's never a good idea because when you make someone's livelihood tied to the number of people that they pick up, they're always going to find someone to pick up.
Right. And let me ask this: I have read, but obviously haven't been able to confirm that. So when they talk about 3,000 arrests, are the arrests counting regardless of whether, because we're seeing a lot of people get arrested and then released. So are they counting the arrests even if people are ultimately being released? Like, is it, a lot of me feels like it's for the optics of it, that like, we're just going to go out there. Everybody should be afraid. Everybody is, everybody's on the table. And, that this sort of, I think it comes from like a desire to project strength, which, I don't personally agree with that. But so these agents they're incentivized to find people to arrest. So they're just, it seems like in many cases indiscriminately stopping people who look like they're non-American, which
which I think is what, some people may have heard the term Kavanaugh stops, which,
it's interesting. I wonder if, because that decision was on the very sort of, I don't remember what month it was, but sort of on the front end. And I wonder if he would have a different perception now that we have seen how it's been.
I think he's tried to walk it back since then.
Mm-hmm.
I think he might be, I don't want to necessarily speak for him, obviously. I don't know what's going through his head, but he's definitely tried to walk it back a little bit. But I think that's a genie that's been let out of the bottle. I think.
Can you, just so people know, when you say Kavanaugh stops, what are we referring to?
Sure. So what happened was during sort of one of the beginning stages of the immigration crackdown in LA,
right,
the Ninth Circuit had put in a stay where they did not permit, from a district court stay, they affirmed a district court stay, that did not permit Customs and Border Patrol or ICE to arrest people based solely on their race or where they happened to be at the time, like Home Depot parking lots, they were going and rounding people up, their apparent ethnicity, whether they were speaking a language other than English. And the Supreme Court vacated that stay, and Kavanaugh wrote a little statement, very short, basically saying that these are, appropriate things that law enforcement can take into consideration when evaluating whether there's probable cause for an immigration-related arrest. But in a country as diverse as the United States, where so much of the population who's born here speaks Spanish, where we have Puerto Rico as a territory, where
or his little brown skin,
right, and this has hit a number of people too as well. Like there have been a number of Native American nations who have seen members of their population who have been arrested because they, looked Latino, whatever that means. And, we're seeing this up in Maine right now with the populations up there who are from Africa. Of course, this is happening in Minnesota. It calls into kind of question what it, I think, means to be an American, because in the history of America, we've always had this tension between being a nation of immigrants, having people come in, adding their experiences and their cultures to the American landscape, but also the sort of nativist push. Right. And what that nativist component is has changed over time as new members of the sort of American society have adapted in. Right. So, my ethnic background is principally Irish and Polish. 100 years ago, 150 years ago, I wouldn't have been considered American. Right. Nowadays, nobody would ever think that. Right. So it's this tension, though, is, I think, particularly frustrating for a lot of members of the Latino community, because Latinos have been part of America since its founding, especially in the Southwest. And I think we're trying to figure out how to resolve this. Like, what does it mean to, if you have someone who is not white or is not speaking English, what does it say about your thoughts about Americanness?
Right.
For you to come to the conclusion that they must not be from here.
Right.
I think that kind of what we're seeing, I think, is sort of the dark underbelly a little bit of our society, and it's coming to the fore. And I think it's really unfortunate that so many people are getting caught up in this dragnet right now.
Well, and I think that's an interesting point, because I do think, just the sort of rise of the internet and social media and this really hyper partisan politics world that we live in, obviously we have always had this sort of subculture of people who think like that if you don't have
Right.
light skin, that, well, you don't fit into the idea of America. But, those sort of subcultures didn't really have the opportunity to thrive. They were, you might have a little somebody with a newsletter here, or, this and that. And with the internet, all of these ideas sort of came to the surface and then get promoted as, this is the way we should be thinking. And, the reason why my life is bad and things aren't going well is, it's anybody who's brown and doesn't look like me and maybe, has a little bit of a different culture, which is, it's just really so disappointing as a whole, because I've just been very disappointed in a lot of things happening in America these days, because most of it seems so anti-American to me,
Right.
And it doesn't mean that you have to think that everybody should just come and there should be no rules. But this idea that, well, if you don't look like me or sound like me, then you're not American, and I do think it's important to point out, just like you said, that, particularly in the Boston area in the early 1900s, I mean, the reason I grew up in South Boston was because we were all sort of pushed into our own area, that we weren't really welcome in a lot of other places, and people forget that very quickly. And now our own Irish culture has sort of assimilated into American culture, and luckily my skin is, somebody with Irish descent is light enough that I guess I get to be considered an American. But if you're somebody who's comes from a different
Right.
cultural background and born here, that you would be eligible to be stopped just because of the way you look is so antithetical to what we are supposed to be as a country.
Yeah, no, I agree completely. America really was founded on these sort of ideas based in the Enlightenment. It's enshrined in our Constitution. Somebody who naturalized yesterday is just as much of an American as
Right.
me. And that's a hill I'll die on. I think that's very, very important.
Yeah.
It's our concept of being an American is adherence to the principles in the Constitution.
Right.
And my great fear is, as if we begin to deviate from those ideals, even if people think it's going to fix the problem of immigration, the problem of border surges, the problem of how to deal with this sort of inflexible issue of the sheer numbers of people we have. If we abandoned the Constitution in order to fix that problem, who do we become?
Right. And I think, it's a sort of bigger topic, but I just think this, I think we have become very complacent as a country, and we don't really recognize what the importance of our rights to the whole thing working, right? We can't just apply our rights the way we want to, or the things that we like. The most important part of the Constitution is that those protections apply to the things that we don't like, and to the people who are different than us. And we have to, as individual American citizens, in order for the whole thing to work, we all have to recognize that has to be applied equally across the spectrum, not just to those with the political ideologies that align with us. And speaking about what's going on, across the country. And obviously we see sort of the limelight on Minnesota. What is your, we get this, I often get this sort of like pushback of, people, ICE is just doing their job, they're just enforcing. But the idea that 3,000 agents were sent into a city of 43,000. I think if I'm correct, the estimated illegal immigrants in Minnesota are somewhere in the like 125 to 150,000 range. It seems so disproportionate that, from my perspective, this doesn't really seem like an actual enforcement action. This seems to me to be meant to instill fear, to show sort of this idea of like brute strength that, if you push it against us, then too bad, you come with us, you're getting maced, you're getting pushed, you're getting shot. This sort of escalation, which has happened so quickly. From your perspective, do you see, how can we, is there a way for them to effectively enforce the rules in a situation like Minneapolis now? Like it in my mind, I'm like, you got to just completely pull out and reset. But I don't know that that's going to happen. So what do you see in how enforcement is being conducted now versus how it was conducted in all of the administrations that you were employed in prior to this? And those are both Democratic and Republican administrations.
Yeah, so I really think it's just leaps and bounds different. There were occasionally situations where ICE would have operations in a community,
Sure.
Especially if they were oriented around, a belief that a gang had started to
Yep.
become involved in a community or things like that. They would go and they would round up a huge number of people at once, or they would start these initiations if they believed there had been, certain communities that engaged in a large amount of marriage fraud associated with certain attorneys' offices.
Yep.
They would do investigations that were targeted and would do in-home raids and things of that nature. But this is different. I think obviously there's always going to be situations where there's critiques about law enforcement
Sure.
operations. That's endemic and
Sure.
kind
Comes
of
with the
intrinsic to the territory. But I think what's happening here, this administration has unfortunately so often used the FBI and ICE too to seemingly target political opponents or areas of the country that didn't vote for the president. And I think it's doing a real disservice to the people in these law enforcement agencies who are going to have to spend probably decades now rehabilitating the image of not just their own organizations, but law enforcement in general. And I think it's also shifting the culture inside these organizations. As new agents come in, what does it mean to, frankly, be hated by the local community? That's going to affect you, and that's going to change how you do your policing. It's going to change how you do your enforcement engagement. It's going to change how you question suspects and how you question witnesses. Because if you're coming at it from the perspective of these people don't want me here and these people hate who I am and what I do,
Right.
you're going to be more antagonistic. It's just human
Right.
nature.
Right.
And I think ultimately in the long run, this is going to really, really hurt our ability to respond to some genuine problems that we have with immigration in this country.
Well, I think that's an interesting point because, when you are, I often think about that over the last sort of, maybe 5-6 years, that law enforcement, with defund the police and sort of this, shift in perspective, that I think it is difficult. I do. I genuinely think it's difficult in many circumstances to be a police officer, to be a federal agent, because the trust has slowly, I think we are a country that generally, even though it's kind of weird because even though we're mistrustful of the police and we always want to question and we want to make sure they're, compliant and enforcing the law, within the boundaries of, the Constitution. But that at the same time, we also, I think collectively know and understand that we need police, right? We need police, we need law enforcement, but now you have, as you say, individuals who have been in the system for a long time, and this is just that now when they're out on the streets, they are just facing constant opposition because, it's sort of this back and forth. And how do we, de-escalate this? And then on top of it, we have what seems to be an incentivized system for particularly new agents. We have, I printed these out actually. I thought they were really interesting on the Department of Justice website. Oh, that's the this is You Be the Judge. How bright the next chapter of America applied today to become a deportation judge. Like, I'm like, I don't think that's particularly helpful to, instilling trust in the system. And then the other was America needs you. And I'll put these up on the screen when I have it up. America has been invaded by criminals and predators. We need you, in capital letters, to get them out. You do not need an undergraduate degree. So these are these are the ads for who they want to sign up for the system. So if you're signing up for ICE, you get in a $50,000 bonus. And I think it's attracting the underbelly. I think it seems like we have just sort of dismantled I think you're right in that it's going to take decades to fix this, because in such a short period of time, they have completely undercut the sort of inherent trust that many of us have had in law enforcement, that like, okay, but the system, as lawyers, we're sort of taught this is where the last line of defense, right? The lawyers, the judges, the people in the system are the ones who are going to ensure that the system works. And that in order for that to happen, we all have to, we all swear an oath to the Constitution. And that means that we have to hold ourselves to a higher standard. And it just seems like that's not happening anymore. And I just can't impress upon people enough how concerning it is that this is, that we have gotten to this place in America, really.
Yeah, no, I agree. I think there's always been fair criticisms of policing in this country, with disparate treatment based on racial background in different communities who are impoverished, seeing, probably more policing than they need, whereas more wealthy communities are kind of left alone.
Yeah.
I think there's been legitimate critiques, obviously, and we have needed for a while a discussion on how to change policing for the modern age. And,
Sure.
But I think what's going on here is, especially with these kinds of advertisements,
I know.
What you want in policing and what you want in law enforcement, what you want in prosecutors' offices, what you want in the judiciary is people who are going to behave with integrity, who are going to uphold their oath to the law, uphold their oath to the Constitution, actually have compassion and care about the communities that they're engaged with. And I worry that what is being solicited here is people who have no interest in that, but are interested in power over, not power with or power for, people who are interested in, we're not looking at the best of the best.
No.
Is my concern.
And do you, if in a place like Minneapolis, so is there sort of a mix of probably law enforcement who has been with, working for ICE, CBP for a long time, mixed in with kind of these, excited newbies who, not to diminish the severity of it, but sometimes it feels like I feel like people think it's a video game, and it's like, we got these big guns, and, we got, I don't know, like, you're all dressed up, and you got the tactical stuff, and the mask, and this, and you have the power. I mean, I can't, like, it's like we're seeing live in action how power corrupts,
And the thing is, it doesn't have to be that way either, because we expect an 18-year-old private just out of boot camp who's been deployed to a foreign country where they don't speak the language in an active war zone to have more trigger discipline than ICE is currently demonstrating.
That's right.
And the other thing I think that's in Minneapolis that's occurring as well is a lot of the ICE agents that are on the streets there are not local to that area. They're being trucked in from Texas or other locations. And I think that also affects the way that they're doing the policing, because that's not their community.
Right.
They don't know the area.
Right.
They don't necessarily have the same subconscious realization that these are my neighbors.
Right.
And I think that that's also probably having an impact as well. It has the feel and texture of an invading force, of outsiders coming in, but without the discipline that you would see with the U.S. military.
Right. That's right. Well, you know, and I've seen, you know, just various commentary from individuals who have served and said, like, if I did that in another country, I'd be court-martialed, you know?
Yes.
So why is it that not only are we seeing this happen, you know, live on television, and then we're hearing from the United States government that no investigation, it's just, you know, on its face, fine, no problem. I mean, in the original aftermath of the Renee Good shooting, I think it's shortly thereafter, Bovino, I always forget his first name, Greg maybe, you know, said they're just someplace else. They're still on the force, and not that they should lose their jobs immediately, but I mean, everybody knows their practices. If you're involved in a shooting, particularly when someone's killed, you're immediately going on administrative leave,
Yep.
pending an investigation. It doesn't mean you did anything wrong. It's just that's the way it goes. So the idea that not only for the integrity of any investigation, but also for the individuals who just shot and killed a civilian, right? Like for their own mental health, we're supposed to be taking a step back. And so, you know, I think you see this sort of, it's you have the United States government from the Trump administration down, really giving all of these agents, I think, in the street, the authority to do whatever they want. I mean, Stephen Miller getting on, you know, TV and saying, you have federal immunity. You have federal immunity, you know, and what message is that supposed to send outside of you can do whatever you want and you're not going to get into trouble?
And well, and not just that, but also I feel we do live in a cynical time. You know,
Sure.
I do see now that every time in the media when anyone discusses a federal judge issuing a decision, they always now say who appointed them.
It's so frustrating.
Which should not be relevant.
No.
But what really struck me about this is that when there is a law enforcement related incident, it's not that hard to figure out what to say to the press.
That's right.
Everybody knows.
That's right.
You come up and you say, we're awaiting the investigation. We're going to thoroughly look at this. They've been placed on leave. I want to assure everybody that we're doing, you know, we're looking at this with the most detailed lens, and we're going to leave no stone unturned, and we're going to know what happened.
Yep.
That's not what they did.
No.
They, within, you know, hours of the incident, were out there labeling people as domestic terrorists,
Right.
stating they knew exactly what happened and posting social media pictures of the
Right.
Gun.
Right.
So this is...
Which is it, and I think on another level, you know, it really just shows. I mean, it just shows how entrenched we are in our own political, you know, ideologies. Because objectively, you know, when you think about the Alex Preddy shooting, it's hard for me to believe that anybody, if you take politics, if you take all your ideologies out of your mind, that you can not objectively say that clearly this was the guy shouldn't have been shot. You know what I mean? Like, I don't even know that you had I mean, I don't think personally, I don't think they had a basis to spray him in the face, take him to the ground. You know what I mean? They created the situation in which, you know, an American citizen lost their right for arguably exercising their Second Amendment right, which, you know, to then watch the head of DHS, Christine Ohm, and Greg Bovino, and Stephen Miller, and J.D. Vance retweeting this story that's just like a figment of imagination, presented by the United States government in this administration. It's almost, it's so hard for me. It is so hard for me to believe, to watch them get on there and say, you know, that this guy's a domestic terrorist, that he came armed, that he intended to do mass amounts of destruction, which is just objectively false, you know. And it's difficult because I want people to trust the system.
Exactly.
You know what I mean? I want, my goal with my objection with all of this is that there are good people in the system, that we're trying to, you know, you want people, the only way the system works is if there's faith and trust in the system. And when you have individuals get up and lie.
Yes.
I mean, people who have sworn an oath to the Constitution, and you get up and lie, not like little smidge here and there, like lie, I mean, isn't that, it's like, that's the whole ballgame. Like, this is, so for me, it's been very eye-opening to see how far they are willing to take it.
And frankly, if I worked for ICE, I would be terrified right now because let's say there was a situation where there was a justified killing.
That's right.
No one will believe
No,
it.
that's right.
No one will believe it.
That's
And that
right.
person is going to face that stigma for the rest of their lives.
That's right. That's right. And that's what, and that's why we need people who know what they're doing at the top. We need people who understand immigration. I mean, even the idea that, we have individuals who sort of are the figureheads of the whole system that don't have any background in law enforcement or immigration, or the fact that I think now I just saw that they lifted the that now in order to be a judge you don't have to have any immigration experience, which is crazy because how complicated the system is, how nuanced it is, how complex it is.
Well, in fairness, that's not new.
No, it's not new?
It's not new.
Interesting.
No,
Oh,
you needed to
interesting.
have 7 years of legal experience.
Okay.
But you never actually were required to have immigration experience.
Oh,
they
interesting.
they preferred it. It was
Yeah.
vastly preferred, but it wasn't required. Which did lead to some difficulties, I think, with some new judges who didn't have
I
any.
mean,
It's a complicated area of law. It's very hard to get in like a 3-week training course.
I mean, I can't. To me, well, and also especially, as somebody who largely has practiced criminally, I'm like, well, I know my stuff about that, but it's the law is not just the law. This is why we call it the practice of law because it takes a lot of time and effort to get into that process. But I have a couple more questions for you, and then sort of wrap up with your thoughts about something. But in terms of legality, we have seen a lot of federal court judges becoming more vocal as of late, which I think is a smoke signal that people should be paying attention to. And some of it is there's a lot of different issues around immigration and enforcement are being litigated all across the country in a number of different ways. But we have recently seen that the directive from ICE has been that you don't need a warrant to search a house, and now that I might be misinterpreting, so you can correct me, but that basically you don't need an arrest warrant to pick anybody. That anybody who essentially that you can basically take anybody, and you don't need any. I mean, it's so strange for me to even say out loud that you don't have to have gone in front of a judge and established probable cause in order to take somebody, deprive them of their life, liberty, their freedom. What do you think about that? So these agents on the street, I mean, they don't have to follow. I mean, basically what they're being told is the Constitution doesn't matter.
Right. So let me give you some background here. So there have been for a long time these things called administrative warrants.
Okay.
We
hear a lot about those
yes.
these days.
So they're signed by DHS personnel. They're not even signed by an immigration judge. They're just signed by a supervising officer, essentially, in DHS and ICE.
And does it have to be an attorney, or that could
No,
be?
they're usually not. That allows for the arrest of a specific person named in that warrant.
Okay.
And it's the ERO officer, Enforcement Removal Operations Officer, that determines that there's probable cause to say, we believe this person is in the country without status, or this person is not a U.S. citizen.
Okay.
And it doesn't authorize them to pick up anybody who's with that person. It doesn't authorize them to go into their house. It doesn't authorize them to go into their place of work or anything like that. It literally is just, if you confront this person, you are able to take them into immigration custody. The guidance that's come out recently that's been leaked is saying that warrant is sufficient to go into people's homes, which,
Right.
I mean,
the Flood Amendment,
right, like this is unconstitutional in multiple ways.
Yeah.
And the ICE practice now has been that if they have a location, like a house where they believe someone might be there unlawfully, they will go into the home, usually but not necessarily in the early mornings, like 5 o'clock. They are armed. They round up everyone in the home into a central area of the house, like a living room,
Okay.
and then question everybody about their citizenship. And if people cannot prove that they are U.S. citizens, then they'll take them into custody. And of course, proof of U.S. citizenship, a real ID is not sufficient. It has to be a birth certificate or a passport.
And who has that, really? I mean, so theoretically, if I was in, I don't know, how am I going to prove my United States citizenship?
Right.
If somebody stopped me, aside from saying I am, right? So, and is that what in that case, so they have the administrative warrant. So, okay, fair enough. That's the process that you can arrest and detain the individual who you were seeking. All of the other individuals, are these what we are hearing as collateral arrests?
Yes, those are collateral. That's what's referred to as collateral arrests.
Okay. And traditionally, prior to this administration, would we be arresting those people?
It depends. So what would usually happen is the officer would ask the other people, what's your citizenship? Where are you from? Where were you born? Most people don't know that they don't have to answer those questions.
Right.
So most
Right.
people would voluntarily answer the questions. And then once they admitted that they were not born here or that they had citizenship in another country, then they would be taken into custody.
Okay. And previously, there was no, you couldn't enter. If you wanted to go into a house as ICE, would they go to an immigration judge to get a warrant, or
No.
they wouldn't ever do that? How would it work?
Usually what they would do is they would try and knock on the door and try and get people to voluntarily let them in.
Yeah.
Barring that, they might wait outside for people to come out. It was very, very unusual that they would go and actually get a district court judge, a federal district court
Yeah.
judge to sign a warrant.
Yeah.
Just because, again, these are administrative procedures.
right.
We're talking
Right.
about civil enforcement. This is the equivalent to enforcing tax code
Right.
or enforcing EPA regulations or enforcing FAA regulations about how high you can have something on your property in the path of an airport.
Right.
These-
So you're not clogging up the docket in federal court to get a warrant. For anything
Exactly.
Like this. Right. And one of the things that probably concerns, aside the fact that they're entering houses without warrants, which is, it's like I was saying before, I do think that part of this is that we, as a country, I think, have not, I don't know if that we haven't prioritized sort of civics and educating our citizenry on what the Constitution is and what the principles, and the whole purpose of the Fourth Amendment was that, when you're in your own space, that in order for the government to intrude upon that, they have to show, certain
good
things
reason,
to
yeah.
a judge, and a judge an independent arbiter has to say, yeah, you're right. We can violate someone's right to privacy and in their own home because A, B, C, and D. So this idea that, that federal law enforcement could just come into your home and sort of gather everybody up is, deeply concerning. And even more so to me, I was interested in this, that, in criminal court, if you have a bad search, the evidence gets thrown out, right?
Yeah,
And
yeah.
essentially the case goes away. But in immigration court, what it seems like to me is that, there is no remedy there is no motion to suppress. There is no remedy that way. So even if it's a bad search and you go in and get people, despite the fact that you don't have a warrant, once you have the person, there's no real recourse for that.
Yeah, the concept of rights without remedies. So there is. So in 1984, the Supreme Court, in a case INS v. Lopez Mendoza, said that generally speaking, the exclusionary rule doesn't apply in removal proceedings, and their basis for that was that was kind of twofold. First of all, these are civil; they're not criminal
Sure.
proceedings, and secondly, they said that there's a national security interest in allowing the government to pick up people who are here unlawfully and to have them go through sort of the proper
Right.
removal procedure. The idea being that if someone sort of maintains their status illegally in the United States in limbo, effectively, if we have a fruit of the poisonous tree doctrine where we're excluding any evidence gained from an unlawful search, they could stay
Right.
here forever and we'll
Right.
never be able to
Right.
put them in proceedings. They did leave open the possibility that their result might be different if there were what they refer to as egregious violations of the Fourth Amendment, or if those violations became very widespread and people were being prejudiced by them. And some circuit courts have held that in the event of an egregious violation, that suppression is available. But you can't suppress the body, meaning the physical person. So if they're picked up, you can't. And, but
it's almost like, well, and that's why, to me, it's like, there is no incentive to follow the law because they know, well, we're just going to go in. We're not going to get in trouble. We're going to get them in front of a judge. A judge is going to sign the stipulation, or they're not going to get them in front of a judge. They're going to sign a stipulation, or, and then they're gone. And, and it doesn't mean that person shouldn't have been gone anyway, but it's, we want to ensure that when we make serious decisions in our court system, that we have done everything fairly and consistently with Constitution. That's sort of the whole principle, is that, I could get caught with a kilo of cocaine, but if you came in here without a warrant and that goes out, yes, like that is what the Constitution does. It, like, even though I did something wrong, it's more important that the government did something wrong. And because of that, I'm going to get away with it. And so it's not that, it's not that these rights aren't meant to protect bad behavior, but sometimes in order to ensure that the system functions, that's the natural effect, right? But if there's no consequences for, hey, if you can come in and get 10 people who are illegal, then what does it matter? What is anybody gonna do about it?
Right.
And so that's what's concerning to me, is like, that's why I've always been a little extra, always tell people, I'm like, local law enforcement, state law enforcement, I'm like, but the feds, no one really polices the feds. And so we're looking at that happening in real time, that they're the ones we call in when things are going bad, at the local, the state level, who makes sure they follow,
who watches the
rules,
watchman.
Yeah,
and now we don't even really have Bivens actions in the context of immigration enforcement. As of 2022, the Supreme Court said, hey, in the context of immigration, like this was a court-created remedy. And just in case, I don't know if your viewers would know what a Bivens action is, but
probably not, so thank you.
a Bivens action was sort of a court-created remedy to address when you have intentional violations of people's constitutional rights.
Okay.
If the government unintentionally violates the rights through negligence or something like that, then there's the Federal Tort Claims Act, where you can sue the federal government. And if a state or local government violates someone's constitutional rights, there's what's called a 1983 action, where you can sue the state or local government. But Congress has never created an equivalent for the federal government. And so the Supreme Court, decades ago, in the Bivens case, said if there is an intentional act by which an officer of the federal government operating under color of law in their official capacity intentionally violates someone's constitutional rights, you can sue that officer.
Right.
Well, in 2022, there was a case that came up where someone had property, and he owned, I believe it was a bed and breakfast.
Okay.
And an immigration, I believe it was Customs and Border Patrol agent, came onto the property without a warrant and began sort of harassing his guests, demanding to know where they were from and things like that. And I think there was an assault that was involved in there as well. And the person sued the agent, and the Supreme Court said, look, in the context of immigration enforcement, we think it's so important that agents essentially be able to do what they need to do, that we're not going to permit you to sue them on an individual basis, even when they intentionally and knowingly violate people's rights. So as a consequence, not only do we not have motions to suppress really available in immigration court in most contexts, also the agent there's no lawsuit availability against the agent. So I think what's kind of kept things going so far is these internal enforcement mechanisms where the agency usually more or less polices itself. A complaint will be made, the agent will be investigated or put on leave. People don't want to have congressional inquiries, so the higher-ups will try and sort of internally police things. Now we're finding a situation where those mechanisms are not being done, and it's being left to the courts, but the courts don't have a remedy. Their hands are tied. Nothing. There's really no availability for them to do anything. And so I think that's where you're starting to see these judicial court orders that are almost getting bombastic sometimes in their language. They're really, really unprecedented, the language we're seeing come from some of these immigration cases that are coming out of the federal courts.
Well, and I think too that probably, if you're not in the legal system, that you might not sort of recognize that these are not normal type decisions from,
Yeah,
I mean,
not
it's
at all.
particularly from federal courts.
Right.
I mean, they really, listen, we have all different kinds of, levels of within our judicial system, but there's a real deference to federal courts and federal court judges. And like you mentioned earlier, this idea that people are always say, oh, well, it's a Obama activist judge. Oh, well, it's a, Trump. I mean, in my experience, if you're on the federal bench, you are somebody who is well respected, who has probably litigated in a variety of areas, and who really understands the consequences of their decisions, and I think, and I trust it, and I trust in the system enough that if you get to that point, that you are a United States District Court judge or appellate court judge or, the United States Supreme Court, that you really understand that interpretation and application of the law outside of political ideology is what keeps us functioning as a democracy. And so to see the language in these federal courts decisions, I think it was, is it Judge Schultz, who's the Chief Justice of the United States District Court in Minneapolis, who had originally ordered Todd Lyons to come and appear because, again, ICE was not following court orders. And that issue became moot because the government dismissed the case, but which, again, is a mechanism to get out of responsibility. I want people to understand that by dismissing the case, that means he doesn't have to appear, but the judge included a list of, I think it was 78 or 79 cases in which ICE had just flouted, and so, and then we have the case of the 5-year-old who was taken and then sent to Texas, and the district court judge down there, scored in Benjamin Franklin, and
the Declaration of Independence, which is not a legal document in the U.S., but yeah.
And so, you have, it's about as, that's what I want people to understand. When you have federal judges writing decisions like this, it means everything's on fire. People need to pay attention, and people need to take their sort of partisan perspective out of it. But, unfortunately, I think we live in a world now where, everybody is sort of incentivized to keep us, divided and ignoring these very, very, very serious, really violations of like what the fundamental principles of America are.
Yeah. Ordinarily, federal judges are very staid, very distinguished people.
Yes.
Law nerds like me, we read a federal decision, and even if there's a little bit of snark in it, we send it to each other because it's like, ooh, the judge got a little fiery. What's happening now is just completely unprecedented, and I really hope that people realize when you have folks who have spent their entire career in as conservative a field as the law,
That's right.
who are not activists, who are sworn to uphold the law, who have done that their entire careers, who are sitting there and saying, this needs to stop, this is unusual, this is a threat to our constitutional democracy, that really should be bright, flashing lights.
Yep. People need to be paying attention to that. And I think, and as I said to you, I think it's, many of us have gotten to the point who, whether we're just practicing attorneys or judges, where I think I'll speak for myself, and it seems reflective in sort of what's going on. You being courageous enough to speak about this publicly. I think I can't not emphasize it, because I think a lot of people are afraid to speak the truth because sometimes it's unpopular, but it's most important that those of us who have been entrusted as sort of keepers of democracy, I take my oath to the Constitution very seriously. I really do. And so when you have individuals such as yourself, having to resign, and you have federal judges, I can't emphasize enough how important it is for people to pay attention. And so I think it's, but it gives me hope that there are enough of us who are starting to be, vocal about, this isn't about politics. This isn't about Democrat. This isn't about Republican. This is about America and what the principles of American values are. And really, I'm just starting to read David McCullough's John Adams, because now I'm like, okay, I need to I just want to refresh, because it's important. It's important. I always tell everybody, I'm like, if you don't want to read, go watch John Adams, the miniseries with Paul Giamatti on HBO, because it's excellent. And it really, I do think that talking about this kind of stuff, even though it's complicated and it's dense, it's important that we educate people on what is really going on, what should be going on, what are the things that are happening within the system. So I could literally talk to you all day, so I'm not going to keep you here all day, but I would like to know, just sort of as like a kind of wrapping up, if you had like a magic wand and you could design how the system, like what are the things that you would fix first, or you think are kind of like, how do we, to me it almost feels like it needs to be dismantled and start from the ground up, and I don't know if that's realistic, but are there things that you think are realistic that could actually have an effect on moving forward into an effective, respectful, responsible immigration system?
Yeah, well, we already talked a little bit about moving the immigration courts into Article 3.
Yeah.
And I do think that we need to have improved border security. But I think what that looks like is not necessarily walls and people with guns. I think we need to have increased checkpoints. I think we need to have more border crossings that are available. And I think also one thing that often gets left out in this conversation is that immigration is a byproduct of problems usually that are happening elsewhere in the world. People don't...
Some of them which we've created.
People don't...
Which, I think is part of the analysis that people don't pay attention, that, we have, destabilized a lot of the countries that people are coming from.
Right, exactly. The MS-13 was originally an LA street gang until the late 80s and 90s when we started removing a lot of them to El Salvador, which had just come through a very, very brutal civil war, partially caused by United States interference.
Yep.
And they found a power vacuum with a lot of guns and were able to set up a drug trade, a lucrative drug trade, and almost succeed in taking over the country. And this pattern has sort of persisted, that we have destabilization in an area of the world. Naturally, people want to migrate either to Europe or the United States or other areas that are more stable. And so to some extent, these problems are not ones that can be solved here, but they can be solved by more conscientious foreign policy. And I don't think that isolationism is necessarily our friend there. I also don't think necessarily that American interventionism is our friend either. But and we've kind of vacillated between those two extremes. But I think that if we were able to have more positive relationships with our neighbors in especially the Western Hemisphere, and we're able to actually create good economic growth and stability in a lot of those countries, we would see most of our immigration problems honestly dry up. It takes a lot for someone to want to move. They're leaving behind their moms, their dads, where their grandmothers are buried. They're leaving behind sometimes children. They're leaving behind their houses, their jobs. I so many times in immigration court heard people say, "What's the likelihood that I'm going to be able to get my case adjudicated by next year? My mom has cancer. I want to go home."
Right, and you can't. And that's a thing that a lot of people don't think about is like, you come here and then you might not see it. Some people don't see their family
for decades,
ever again,
right? So I think that that's really one of the key pieces that's missing here. Is if I had a magic wand, I think what I would do is I would fix the way that we engage with a lot of our neighbors.
And it's really interesting because sometimes it just feels like we've gotten to this place where, because it's difficult, because it's a complicated subject, because there is no easy fix or, fast solution, that somehow we have, stopped talking about things and stopped, I think most Americans, to be honest, were maybe not directly in support of, but a lot of people, even who didn't vote for Trump, were supportive of some kind of immigration reform change. So I think when you look at America, in everyday people who are not in the system, they say like, yeah, there's a problem. We need to change it. We need to fix it. But because we have become so polarized, we don't even have these conversations about like, okay, what are the options? Like, what are the things we can consider? Okay, we'll do a little bit of this. We'll do a little bit of that. Like maybe reevaluate. But, all we can do is use our voices and our knowledge and try to, give people as much information about what's actually going on. And that's why I really, I know I've said it, but I really want to emphasize how grateful I am for you to come here and talk about this. And I think it's immensely courageous to do what you did after having served in the government, but really after having served for this United States, as a civil servant. I think we don't give enough credit to our civil servants who have worked really hard to do their best for this country, and to have to feel like in order to keep doing that you have to leave, the job that you worked so hard for. So I want to thank you again. And I will just ask to finish, is there anything, I'm sure there's lots that we haven't covered, but is there anything that you think I've missed, or you think it's important to say, or is there anything else that you want to say as part of this, kind of conversation?
Well, I mean, in all honesty, immigration is so complicated. I feel like we barely even touched on the beginning of it. I've been doing it for 18 years, and I don't even know that I wouldn't consider myself an expert on all of its facets.
Well, you seem like an expert to me.
But I would just say, if immigration is one of those areas, it's become very much a touchstone. People have a lot of opinions on it. And I think in a democracy, people should have opinions on matters of public concern. But I also think that I'm really grateful for you to have shows like this and other ways that people can do research and kind of look into things on their own without listening to just the sound bites that they're hearing from partisan sources, because it is important, I believe, in a civil democracy for people to be educated and aware of the underlying issues for what's going on. And so, yeah, thank you.
Sarah Cade, this was a great conversation. I think you might be my longest episode yet. Josh would probably tell me, but I'm like, I know if we could stay here all day long. So once again, I want to say thank you so much. I might be checking in as I'm sure we will have lots of other issues that arise and need to get your expertise. But once again, thank you. And I hope that despite the fact that you are now on a different, unanticipated, stage in your career, that you thrive and flourish in everything that you're doing. And I appreciate your service to this country. And it's we need more of it. So thanks very much.
Thank you.
If you like this episode, please comment, like, share, and subscribe. Every bit helps. Thanks for watching Note My Objection. See you next week.